only, it's important that you still observe the mechanics of the open meeting law, meaning you start an open session, you have your motion to go into executive session, your 2/3 roll call vote, and then when you're done, you come out of the executive session and then adjourn the meeting. Agenda is required for each meeting. You can amend the agenda up to 48 hours prior to the meeting simply by posting an amended agenda. And you can do that because that's what the law requires, 48-hour agenda notice. So you can amend that agenda if you posted earlier all the way up until 48 hours, no problem. If you get inside the 48-hour window, you post the amended agenda, and then at the start of the meeting, you approve your amended agenda. And then, if you need, for whatever reason, to amend your agenda after the meeting has started, which is possible, it could occur, you have to make a motion, have a good faith reason for why you're amending the agenda, and then take a vote on whether or not to amend the agenda. And all of that is done in the open. And the whole point of this is to avoid a technique that we've observed, I think we call it sandbagging, where you have a really controversial topic, and you look out into the crowd and see that there's only 2 people there and none of them are from the press, and so you say, let's throw the nuclear power plant from our example at the cafe up on there. And so that's why we've tried to err on the side of providing as much notice as possible and document the reasons for amending that agenda. The agenda should include all items known to be probable items of discussion. And so if you think you're going to talk about it, you should put it on your agenda. Conduct of the meetings. All meetings of a governing body are open to the public. That's a restatement of that preamble. You can't hold your meeting any place where discrimination on the basis of race, creed, color, sex, age, or national origin is occurring. I don't know that we really have that problem in Idaho. I haven't heard a complaint yet, really, on that one. The other thing I will tell you about the conduct of the meeting is sometimes we get questions on how we should conduct our meeting. Those aren't open meeting laws, those are more mechanics, but I would recommend that you have some sort of rules of procedure. Parliamentary procedure can be very effective when you're running a meeting, so Robert's Rules or Mason's Manual, whatever you think works the best. I encourage you to have some set of parliamentary rules for conducting your meeting. They can be a tremendous asset. Meetings can be conducted using telecommunications devices. The requirement, if you're going to have a telecommunication meeting, is that you have to have either a staff member or a board member in the room with whatever the telecommunications device is. The goal there is to avoid the Space Odyssey 2001 scenario where you go into the...
You can't even get the name of the film right.
2001 Space Odyssey. Directed by Stanley Kubrick in 1968. So you avoid the white room with the black box scenario. And that's a requirement for that. Recording of a meeting, we get questions about whether or not meetings can be recorded, and the answer is yes, as long as they don't interfere with the conduct of the meeting. And so, for example, this session is being recorded, but it's being recorded without intruding. From the back, it's not... Now, if all of a sudden it changed to where they're zooming up front and getting close-ups and everything else, you could probably stop the meeting and say, you can continue to record, but you need to stay behind the folks, because everybody else here is equally entitled to observe. And so that's how you can handle that situation. Members of a public board cannot use computers or text one another during the meeting. Otherwise, there's no point in even having an open meeting law. If you just sit up there and text back and forth, and then you're like, okay, we're adjourned, all done.
I like it, I like it.
And so, I mean, it'd probably speed it up, but you can't do that. Beware also within the office of email. Reply to all. A lot of times, what happens with the board is you'll have staff members who give you information, and they'll send the information to all the board members, and a board member will get really excited about the information that they've received and hit reply all. Now you're deliberating towards a decision, and so you've got a problem. So beware of reply all. If you're going to make a comment, remember to comment directly back to that staff member. If you make a mistake, and you will. I will come clean. I have accidentally replied to all, and quite honestly, it just embarrassed myself. Because I thought I was replying to someone else, and I had a snarky comment that email and humor don't mix, as we've all learned many times. There's no sarcasm font, and there really needs to be. $1 million idea, by the way, if there is looking for one. But anyway, if you do make that mistake, the best way to fix it is at your very next meeting, when that item is up, say, I sent an email to everybody, it's in the record, I brought copies of it for anybody that wants to take a look at it. Now you've cleaned it up, because everybody can see, you're not hiding anything, you brought it out into the open. Sunshine is your friend. The other thing that I will tell you is, with cell phones and computers and laptops, two further cautionary tales. Number one, be careful about what I call the wall of screens, where folks come into a meeting and they're ready to interact with you and present their information that they've been working very hard on, they're personally vested in, and they look up and they don't see any faces, but rather they see a wall of laptop screens. It's very frustrating for citizens. I 100% recognize that when you're going through ordinances and other information, it's easy to do it on your laptop, but make sure that if you're doing it, you're remaining actively engaged, because there are magic magnets on computer screens that suck you in. And the other thing with computer screens is, if you've got a computer screen or a smartphone out on the desk, as I said, as we all observed before, sometimes government can get a little slow, and we want to know how the vandals are doing, and so you're like, I'm just going to check the score really quick. The problem is, once you're out there in the internet, it's hard to get back, because then you check out the vandal score, and you're like, oh, they're playing Wazoo. Hey, I wonder what happened with Mike Leach today, and you're off. And then you're like, what was that thing at Texas Tech that got him taken down? I wonder what that, and you never come back. So be aware of that. And again, that's one of those things where, are you putting yourself in a situation that makes it difficult to resist the temptation? And so one of the things you may consider as a board is whether or not we get together and we say, you know what, we're not going to bring our cell phones in for these 2 hours. We're going to give it to the constituency. I don't want to give away how old I am, but I have gotten along for about 35, 6 or so years without a cell phone, and more. Thanks, Buzz. But the good news is I'm still here. I mean, nothing has happened without that cell phone. I mean, we actually did survive at one point without them, and so I think that a couple of hours an evening without them isn't going to do any damage to us, and it may actually enhance our ability to govern. So throw that out there solely as a recommendation. Meeting is not required to be open to the public. Is anybody in here on any of those boards? All right, that takes care of that slide. Just so you know, I'm batting 1,000 on that slide. I've yet to. Someday I'm going to be in front of the Public Utilities Commission and get stuck on that slide for half an hour. You have to take written minutes, and the minutes are available to the public. The minutes have to be in writing. Not long ago, we got in a little tiff with the county down south of us, and their argument was that we have a recording of the meeting, and that's the equivalent of written minutes. It went all the way to the Idaho Supreme Court, and the Idaho Supreme Court affirmed our stretch of a legal argument that written minutes means in writing. And so the Supreme Court said, no, it's not a recording, it's written minutes in writing. And so make sure you have them in writing, make sure they're available to the public. I don't want to give away the next presentation, but draft minutes are a public record, and so you don't get like, we're thinking about whether or not they're going to be final. If you've got a draft of them and it's in writing, it's a public record. Get it out. The other question we get on minutes is, how long should it take to get minutes? The difficulty in Idaho is that our open meeting law and public records law are one size fits all. So if you're a board that meets once a quarter, or you're a board that meets every single day, the law applies the same to you. And so that means that reasonableness becomes kind of a fact-dependent scenario. If you meet once a quarter, is it really reasonable that you're going to have your minutes out, within 24 hours? Probably not. You probably don't even have a full-time staff. You're all volunteers. It's going to take you a little bit longer to get those minutes out. If you're meeting every day, you've got 500 employees, you probably shouldn't be taking 2 and 3 weeks to get your minutes out. Based on the level of your sophistication, the reasonableness, how long it takes you to get your minutes out, is going to become important. When you have your minutes, they have to include all members that were present, all the motions and their disposition, and then the results of all votes. That's the bare minimum for minutes. Sometimes we get comments from folks that say, well, I testified in front of the council and they didn't put everything that I said. And our answer is always, well, it's supposed to be a summary of the proceedings so that you can understand what occurred at the meeting. It's not a transcript. And keep that in mind. And then the minutes legally are very important for the entity because that's how you get your presumption of regularity, meaning we're conducting business the way that it's supposed to be conducted, which if you issue bonds or sign contracts is a very important concept. Executive sessions. Executive sessions. They should be the exception, not the rule, for how you conduct business. One of the things that we've actually had come across our desk within the past month is there's an entity that used to have about 1 executive session a month, pretty regularly meeting board, and now all of a sudden they are ramping up and they've got 7 to 10 executive sessions a month. And so red flags are going off. I mean, there should be warning bells there, like, why are you all of a sudden having to go into executive session? It could just be a run of bad luck, but it's one of those things that you have to look at and say, is this something that's going on for a long, long time? When you go into executive session, you shouldn't have blanket executive sessions, notices, meaning we might go into executive session and we're just listing all of the reasons that you can go into executive session. It should be, specific. What section are you going in under? And then enough notice so that folks generally know why you're going in. You have to make a motion to it that it identifies a specific subsection, and then you need a roll call vote of at least 2/3 of the members present. It has to be a roll call vote now. The reasons you can go into executive session, hiring and firing are probably the most common reasons that you go in. And remember, these are specific individuals. It's not kind of broad, general, let's talk about whether or not we need a position. And think about each of these exceptions as requiring a specific anchor, meaning whenever you go into an executive session, you can point to an exact person, thing, or project for why you're going into the executive session. Deliberations concerning labor negotiations or to acquire an interest in real property. It's important within that one, it says to acquire. What word is missing in that executive session exemption?
Buy.
Sell. Sell's the missing word, and so there's no exemption for selling. It's just to acquire. And when you stop and think about it, if you're buying it, why would you need to have that executive session protection? Fine. Acquire. Yeah. When you're buying it, why is that important for a city or a county? Money. Yeah, because if you say make an offer at 55, but if they are waffling, we'll go up to 65. What's that start the price at then? 65. It's the same thing with the settlement negotiation. To consider records that are exempt from disclosure. So if you have an exemption in the red book, you can go into an executive session in the blue book. Preliminary negotiations, this is kind of an economic development exception. And then communicate with legal counsel to discuss the legal ramifications of and legal options for pending litigation. Sorry, I have to get caught up with myself. For controversies not yet being litigated or imminently likely to be litigated. Again, you have to have a specific matter that you're going in there, not the streets are icy and we might get sued. It's got to be more specific than that. And And the other thing that I will say about executive sessions is that it's worth doing a little bit of time to avoid kind of the cloud of, oh, they're just going in there again to discuss whatever. One of the things that you can do is, if you're going in under the litigation exemption, it's probably worthwhile to put the case or matter name down. So we're going in under 672345F to discuss the case of state versus X. And that way folks at least know, okay, that's what they're dealing with. A lot of times folks want to go in and just say we're discussing a legal case. Well, that doesn't tell anybody anything. And that's what creates that air of speculation. And so one of the things that you can consider is whether or not we include a matter or a case name. You can't do that in every circumstance. And so, for example, if you're on a school board, you're probably not going to put on your executive session, we're going in to discuss the expulsion of Lawrence Wasden. Because now you've completely defeated the
You
purpose
wouldn't want
of
to
your...
be considering that in the first place.
I don't think anybody in here is on the Commission of Pardons and Parole or Juvenile Corrections. All right, good slide. Risk management. So you can go in to discuss the public agency's risk management. Again, it has to be a specific claim. You have to have that anchor, again, that it's either a claim that has been filed or is about to be filed. Again, think about how you want to provide the notice of that to head off speculation with regard to what's going on in the executive session. Check battery. The exceptions to the general policy in favor of open meetings are narrowly construed. And we put this in there specifically because we, one of the things that we've observed over time with the court system is that the court system takes all the public record stuff and construes it narrowly. When it gets to the open meeting law, it's a little more reluctant to construe the open meeting law narrowly. And I think it's because there's a cultural divide. Because the court, as a system, is used to doing things how? Behind closed doors. When the judge goes in his chambers, the jury meets in secret, the Supreme Court meets in secret. It's just kind of this cultural divide. And so what we did is we thought, well, if the whole goal is openness, then we probably need to narrow how these exceptions should be construed. And so we added this provision in there to narrow the exceptions, so that the court is now on notice that they should be narrowly construed. So again, I return to that opening premise, that if your thought is, how can we shoehorn something into an executive session, you're probably violating that overarching public policy of openness. A couple other things with regard to executive sessions. The entity controls access to the executive session. Meaning if they are hearing a disciplinary matter and they want to call witnesses in, they can bring the witnesses in and then hear from them and say, you leave now. They control that access. If they don't want to have anybody in there, they can do that. If they want to have a bunch of people come in, they can do that. It gets into whether or not it's even worth having an executive session at some level, but the entity controls the access to that session. The one thing they can't do is exclude a fellow board member. And then we get a lot of questions about the confidentiality of executive sessions. And I'm going to give Randy Fife a plug here. He just showed me a couple of the manuals that he's put together for the city council here. And Randy's got it dialed in. He's actually got a Q&A on the confidentiality section with regard to executive sessions. It's a very nice summary of the importance of confidentiality within an executive session. That being said, there is no penalty in Idaho law for if you go into an executive session and then you just blab everything all over town. And we have that occur routinely throughout the state of Idaho. And sometimes people get very frustrated about it. But I think that when you go into executive session, it's important to remember what Ben Franklin said. And Ben Franklin said, the only way you can keep a secret among 3 people is if 2 of them are dead. And then I also would return you back to the fact that Idaho is a notoriously small state. And so just keep that in mind with the executive sessions and know that yes, do everything you can to keep it confidential, but also understand that not everybody thinks the same, and it's very difficult. Bill Thompson actually did a great job with us when we amended the law and going through how we could make meaningful substantive changes to it. And the thing that we really got hung up on was how to deal with the concept of confidentiality in an executive session. And we kind of wrote ourselves into a corner. We could not figure out how to make it enforceable, yet still respect your rights as a board member, as a fully participating board member, cloaked with the First Amendment and all the other things that go with it. So keep that in mind. Keep it confidential, but also, I understand we're human. You can't take a final action in an executive session. Minutes pertaining to an executive session need to include the reference to the specific statutory subsection and provide sufficient detail to identify the purpose and topic. So if you go in to discuss litigation, the best way to do it is executive session under 67-2345F to discuss the case of X versus Y. Minutes of executive session, discussed case of X versus Y. Done.
So you mean you really have to take minutes for an executive session?
Yes, Mr. Attorney General, you do.
Good answer.